Hey guys, it's Anthony Bandiero here with Blue to Gold Law Enforcement Training, bringing you another roadside chat. I'm in studio today because of travel restrictions. So here's today's question. Can you search a tent with probable cause? Now, before I dive into the answer, I want to remind my viewers to please hit subscribe on YouTube and also join me on Facebook. I am trying to create one of the largest communities of cops to get questions answered about legal issues, share tactics, share best approaches, and so forth. And I need your help. We are going to really succeed together, and I want to be at the forefront of that and help my officers succeed. All right. So here's the legal answer. The answer is no. You cannot search a tent with probable cause alone. You need exigency. Now, as courts around the country have held, a person's tent is like a home. It's a temporary home. And because it's like a temporary home, the normal rules apply. And let me give you an example of this. And it might shock a few of you that the officers messed up here, but this is the way it is. A suspect committed home burglaries, and he was living in a tent in kind of like a remote area in a field. The cops made contact with him outside of his tent. While speaking with him, what did they see? They looked into the tent and they saw evidence of the burglaries in plain view, right inside the tent. So they hook him up. So far, so good. Then they go into the tent and secure the property and and actually there's firearms in plain view as well. So they retrieve the stolen property and some firearms, and they go to court. It gets all suppressed. This was likely not the right outcome because it was not articulated correctly. But here's what's going on: when the officers went to court and on the suppression hearing, and they were asked, "Why did you search this tent?" They just said, "Because we had probable cause." Wrong answer. If the tent is lawfully erected, or it's in an area where the government has allowed homeless camps, then it gets essentially Fourth Amendment protections. So let me just kind of clarify this. If the tent is lawfully erected, it's at a campground, it's permitted, it's on somebody's private property, but they've been allowed to stay there, or it's in an area where the government has allowed camping, even if it's illegal, even if it violates a code, if the government has turned a blind eye to it, then the tent gets Fourth Amendment protections. So what the cops did here was just say, look, because it's a tent, it's not a real house. It doesn't. We can actually retrieve the evidence, and the court threw it out. The problem with this case, and I don't know where the prosecutor was on this and why he or she did not recognize it, but the cops most likely had exigency to enter the tent to retrieve the at least the firearms. So, as I told you, that this case was the tent was in a remote area, and oftentimes cops are not going to have the resources to stand by here in the tent, take the guy to jail, have somebody else run to the courthouse. Oftentimes there's calls holding, there's other things going on. There might be some safety issues. If there's other people in the camp area, what stops them from diving towards the tent and grabbing a gun and trying to hurt law enforcement? So what probably should have occurred here is an articulation of exigency to enter and retrieve the evidence. I'm not saying that was the facts here. It seems like it, that the officers at least should have tried to articulate it, but it is true that simply having probable cause is not going to get you in temporary domiciles if they're lawfully erected or in areas where the government has been complacent and allowed people to stay there. To kind of give you another background on this issue, there was a Ninth Circuit case involving LAPD. Now, LA has a infamous Skid Row. I mean, I think I'm guessing here, but I think it's around 30,000 homeless people that live in Skid Row. Now, this is not legal. I mean, LA does not allow people to just erect tents on sidewalks wherever they want. However, LA has allowed this type of camping, and it's, of course, it's gotten out of control. And what happened was LA enacted a policy that if you left your property unattended on the sidewalk, it could be subject to confiscation. And that's what they did. They scooped up these people's tents and their property. They then, I think they gave them very little time to recover it. And then after that, it was all destroyed. And they got sued. LA got sued, LAPD got sued, and they lost because this was not reasonable under the Fourth Amendment. Those are Fourth Amendment seizures, and the Ninth Circuit at least found that it was not reasonable. I do believe that most courts would agree with that just scooping up people's stuff after allowing them for months, years to just live there, and then say, hey, look, if you turn your back on your property and leave to go, go to the soup kitchen or beg for money or whatever, you come back and your stuff is gone, that is not constitutional. So my point here is that just because it's a tent does not mean it doesn't have Fourth Amendment protections. You need either consent from somebody who has apparent authority, you need a exigency, or you're going to need a warrant. The only exception to that, and this does come up a lot in my classes, is officers are called to people's private property. And after the homeowner discover that somebody is illegally sleeping on their property, by far the courts are going to support cops to remove that tent and property immediately. There is no eviction requirement there because the person is trespassing. But if the person has been allowed to sleep on the property by the homeowner, and now the landowner wants to change their position, if under your state law, if that person would have tenancy like a guest turning into a tenant, well, there might have to get eviction orders. And it may be a Fourth Amendment seizure if you get involved and get into the middle of that. I hope this helps. If you want some more clarification on this, let me know. Now, to remind you again, I'm trying to make YouTube and Facebook a go-to place for legal resources for officers nationwide. Please join me there. And until next time, stay safe.
When it comes to legal training, we're the gold standard. Visit bluetogold.com or call 888-579-7796 today to purchase the Search and Seizure Survival Guide, register for a class, or learn how to bring our search and seizure training to your agency.